So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to talk about this piece that came out of the Huffington Post recently, and Trader Joe's attorney is arguing that the National Labor Relations Board is unconstitutional. We've got to talk about this. HuffPost had a public records request where it detailed this exchange, and it came at the start of a trial. The Trader Joe's lawyer was meeting in front of the National Labor Relations Board. Trader Joe's has been accused of like a slew of unfair labor practice charges, quite a bit. The NLRB ruled that Trader Joe illegally fired a union supporter, subjected employees to interrogation, threatened to cut their benefits, and told them deciding to join a union would be futile. And that was the complaint filed on January 12th of 2024. When they met recently, and you had to kind of set the scene, the Trader Joe, the Morgan Lewis, who is the Trader Joe's law firm that's representing them, is before the National Labor Relations Board, and he says, quote, "The National Labor Relations Act, as interpreted and or applied in this matter, including but not limited to the structure and organization of the National Labor Relations Board and the agency's administrative law judges, is unconstitutional." And that's pretty brave because, for one, the National Labor Relations Board doesn't make this decision whether or not it's unconstitutional or constitutional. They're simply in their place that they're in their place. But I think that is a really sort of stunning, way to go in front of the National Labor Relations Board to accuse them of being unconstitutional. And this isn't a new accusation to the National Labor Relations Act. The National Labor Relations Act is also known as the Wagner Act, and that was enacted in 1935 and sponsored by Senator Robert F. Wagner from New York, and it was aimed to address the labor unrest and unequal bargaining power between employers and employees during the Great Depression. But it was ultimately signed into law by President Franklin D. Roosevelt on July 5th, and it was aimed to protect workers' rights. So the challenge came to the act in 1937, where it was held as constitutional. The National Associations of Manufacturers denounced the Wagner Act as unconstitutional. In September 1935, there was a lengthy brief argued against it. And in 1936, when Roosevelt was elected in a landslide, he unveiled his court packing plan, which complained that the Supreme Court was 9 old men who blocked his New Deal plans. And in 1937, in the Jones-McLaughlin case, the Supreme Court actually saved the Wagner Act in 5-4 decision. So they made the decision whether or not it was constitutional, from the threats of being packed, from the threats of the court being packed by Franklin Delano Roosevelt. And so this is actually fairly common. So, for instance, the Fair Labor Standard, many parts of the Fair Labor Standards Act were also considered to be unconstitutional up until Franklin Delano Roosevelt threatened to pack the Supreme Court, where they were found ultimately constitutional. One of the best examples of this is the minimum wage. The minimum wage, national minimum wage, and state minimum wages had long been considered unconstitutional prior to the November 1936 re-election of FDR. Once his threats to pack the court, they pivoted to whichever direction he was wanting to go. And that is a clear violation of the separation of powers that's enshrined in the Constitution. There are 4 main constitutional arguments against the National Labor Relations Board. There's the Appointments Clause violation. The Appointments Clause of the United States Constitution requires that certain high-level federal officers be appointed by the President with the advice and consent of the Senate. Critics have said that the NLRB structure, where members are appointed by the President and confirmed by the Senate, may violate the Appointments Clause because the NLRB has significant quasi-judicial and quasi-legislative powers. In addition, there's separation of powers concerns. Some critics contend that the National Labor Relations Board, as an independent regulatory agency, exercises powers that should be vested in the judiciary or the executive branch. The Constitution establishes a separation of power among the 3 branches of government, and critics argue that the National Labor Relations Board, by combining adjudicatory, rulemaking, and enforcement functions, blur the lines. And I'm somewhat of that mindset. But my biggest problem with the National Labor Relations Board is its delegation of legislative authority. The Constitution grants Congress the power to make laws. Critics of the National Labor Relations Board assert that Congress has delegated excessive legislative authority to the board, allowing it to push rules and regulations that effectively make law without proper congressional approval. In many ways, it's anti-democratic, right? The the Congress has the ability and the power to make these laws. And more importantly, it causes a lot of problems for businesses who have to go back and forth with a different National Labor Relations Board every 4 years, right? The National Labor Relations Board today compared to 4 years ago is completely different, which means that businesses have to act completely different based on whatever winds, the political winds are shifting. And that causes a lot of problems. In addition, there are critics that say that the National Labor Relations Board's procedures and decision-making processes may violate the Due Process Clause of the Fifth Amendment. This includes concerns about the fairness of adjudicatory proceedings and the lack of adequate safeguards for the rights of individuals and businesses subject to the NLRB's actions. So, this is something, this NLRB argument is something that may go in front of the Supreme Court. And I think, I'm not sure that it will rule the way people typically think. I think that the Supreme Court has, a very specific constitutional mindset that I'm not sure results in overturning the National Labor Relations Board. But what do you think? Leave me a comment down below about it. Will the Supreme Court overturn the National Labor Relations Board? They could see this case very soon. Let me know in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.